Your Lordship. Lordship, I beg to mention for listing of a contempt petition, my lord, it was last listed on 11/4/2020, 2025. It may come on 4/6, my lord. Court number 555.
May it please the Lordship. Lordship, I beg to mention item number 30. Lordship, on the instruction of the petitioner, I would like to withdraw this petition. Lordship.
Item 30.
30.
Your Mr.
Lordship, A. Sharma, I am appearing on behalf of YS Mannan.
Mr. A. Sharma, appearing on behalf of Mr. Y.S. Nunn, that the petitioner does not wish to participate any further in the public. Prayer made is not objected to by Mr. Harrier.
Yes, Lordship, all the respondents.
That is on roll. It reported is very sensitive, pending IS around.
Lordship, kindly with the liberty, Lordship.
Why?
Lordship, the petitioner is not is completely bedridden. If he recovers, then he might file again.
Lordship, as per YS Mannan, Lordship, he talked to me. He said that the petitioner is irresponsible, Lordship, due to medical ailments, Lordship. So they want to.
Not respond.
Not responding to the medical these things, Lordship.
Give it liberty.
Lordship.
Obliged, Lordship.
Deeply obliged, Lordship.
Yeah, please, on Lordship. Lordship, with the consent of the other side, I beg to mention item number 7, 26, and 29.
These are part of the series.
Part of the series, Lordship, in this matter, Lordship, in item number 1, few of the cases affidavit is still not filed, Lordship. We have received all the instruction day before yesterday, Lordship. We are filing in item number 1 and 28 and item number 26. The affidavit is still awaiting, Lordship. In item number 1, there are two petitioners. One
How much time do you want?
within 2 weeks, Lordship. Within
But other methods are ready. Oh, my lord may hurt the other method.
I pray, Lordship, after the filing of affidavit, it may be taken, Lordship.
Because once the matter is heard,
Lordship.
Yes.
hearing start. I do not know whether the facts are similar in all cases. It may be different.
Different.
Not exactly similar all the
But
cases.
so in those matters, if they start arguing, and then there is a prayer to
Filing
for filing
affidavit.
the entire effort of hearing the matter.
That might cause difficulty.
That's why, Lordship, we are.
But they are lingering, my lord.
My lord, we are
File
not.
it immediately.
Lordship, we are trying to file because what had happened, Lordship, in item number 1, there are two candidates. One is from BSF, one is for SSB. So bringing those records, Lordship, that's why we are. Otherwise, in all the matters we have filed, Lordship. Only 2 and 3 matters it's remaining, Lordship. Assam Rifle and SSB matters are remaining. Otherwise, all are filed.
Some rifle that
SSB.
you expedite your instruction.
Lordship,
They are not
we are.
interested.
No, Lordship, we have received the instruction, we are filing. Within 2 weeks, Lordship will complete.
Mr. S. Roy submits that with respect to item number
Item number 1, 26, 28.
26 and 28. Right. That we know the other matter.
That is okay.
Fine. After representing some of the that in other matters, meetings are complete.
My lord, complete.
After fine. But for prayer made by fact that all matters may not be exactly similar. We permit the respondent to complete their digging by finding an area in rather big. We give you 4 weeks.
Lordship.
2 weeks to file affidavit, then the are the petitioners availability at item number 1, 26 and 28?
Yes.
My lord, within I am for the item number 8, my lord. Within 2 weeks, if your lordship gives me, so we'll file rejoin that then. Meanwhile,
That's right.
my lord,
Like, would you like to file a rejoin?
within 2 weeks, my lord.
Within 2 weeks will be,
4
we'll
weeks.
suppose that he will file it by the end of
No, my lord. Within 1 week, if your lordship has it.
1 week, it's not possible.
2 weeks, Lordship.
So then we'll proceed for 3 weeks. to
Lordship.
My
file
lord.
your rejoinder. Matter be listed thereafter. This again after the
Lordship.
Lord, if possible, a date may be fixed, my lord. Otherwise, the vacation is coming also.
So therefore, after 3 weeks,
On 24th of June.
so that's the
No, Lordship, less than a 20. This is the last day.
it feels like
Yes.
immediately after you.
On 15th, Lordship. On 15th June. Lordship. Lordship. Let it be on 15th, Lordship. 15th, Lordship.
50
Yes. 15th.
Interim passed earlier, my lord. Maybe
Lordship.
interim orders passed, wherever interim orders are passed. Further.
Much obliged, my lord.
Obliged.
Here, my lord, participant, my lord.
Yes.
Only because of wrong calculation of date of birth, my lord. Initially, it was 56, but subsequently, when he was regularized, he has supplied his all papers, my lord, voter ID, PAN card, etc., everything, all 66. But they have stopped to, my lord, continue my service, my lord, from the August to 2020, my lord. But actually, according to them, my lord, from the year 56 to, my lord, it will be, my lord, up to, my lord, it was up in the till 2016, my lord. First time I want to place, my lord, all papers, my lord. Annexure 1, my lord, kindly perusal also. His appointment letter, my lord. He was appointed.
Yes.
Stopped date was purely temporary, and he was appointed on 19 July 1985. Annexure 1, page 16. Thereafter, regularization order, my lord, page 17, Annexure 2. His service was regularized 7/10/2005. His position is at serial number 53. Here also his date of, my lord, joining is shown as, my lord, 27/1985. Hereafter, school certificate, it was issued, my lord, in the year 2005, my lord. At the time, and also placed at the time of regulation of his service. His date of birth is shown as, my lord, here in this certificate, original copy 21, 28/7/1966. 28/7/1966. It was issued from the particular school, my lord, on 27/5/2005.
Where is that?
Lordship?
Where is that certificate?
Yes, my lord, that is page 21. Page 21, middle. His date of birth as recorded in the admission register was 28/7/1966. It was issued by the headmaster.
When was it issued? 2005.
Yes, my lord, 2005, 27/5/2005.
When did he retire?
according to them, it is 2016, but according to me, 2026, my lord. Now, what is happened, my lord?
Now,
But
this certificate you placed it before the authority.
Authority at the time of regulation of service.
Then?
And thereafter, my lord, next page, letter, my lord, issued on 30/9/2020, Annexure 5. This one is the last letter issued to me. Here in this letter, pursuant to the subject cited above, you are asked to appear before the inquiry committee on 7/10/2020 at 11 a.m. at the office of the executive engineer, PWD Borpeta. So and so. This is for favor of your information regarding your overstate service. Subject is regarding your overstate service. Because, my lord, here also it is in Annexure 6, my lord, page 24. Because it was initially, possibly, it was recorded as 56, 28/12/1956. Dispute is here, my lord, only 28/12/1956. But my lord, PAN card, my certificate, PAN card is also annexed here, Annexure 7, page 25. 28/7/1966. Next, my lord, Aadhaar card. Aadhaar card also it is recorded as, my lord, 28/7/1966. Voter card I have not annexed, but voter card is also along with me. It is also, my lord, 28/7/1966. Next, my lord, page I-card. It was issued. There also, my lord, it is recorded as 28/7/1966. But affidavit opposition, they have filed, my lord, an inquiry report submitted here. 9/8/24, they filed affidavit in opposition. Here they have found that annexure, my lord, that is page 41, my lord. What they found. Page 41, inquiry report. Examination of record. Record examined. Service book of Bolenborough has examined. The date of his superannuation has been recorded as 31/12/16, and service book has duly been signed by the then executive engineer, PWD Borpeta Rural Division, Borpeta. Letter issued by Undersecretary to the Government of Assam, Public Works PWD Department, dated 30 September 2005, has been duly examined. It has been recorded that his date of joining was 27/1985, and the date of superannuation has been recorded 31/12/16 at serial number so and so. School certificate. The date of birth of Bolenborough has been recorded 31/12/56, issued by the principal Pakka Higher Secondary School. Yes, which is exactly the same as recorded in the service book issued by the then executive engineer, PWD Borpeta. But dispute comes when, my lord, page 42, middle portion, 1/10/2020. On 1/10/2020, the undersigned held a meeting with Prafulla Chandra Das, Deputy Accounts Officer, and Sri Diwan Nayan Ali Ahmed, Assistant Accounts Officer, wherein they furnished the following facts with the record after full scrutiny. Copy of the service book, letter issued by the Secretary to the Government of Assam, so school certificate of Sri Bolenborough, where his date of birth has been recorded as 31/12/1956. Now, next paragraph. Here have been starting facts produced before the undersigned with the following information. School certificate Bolenborough, where his date of birth has been recorded on 31/12/66, issued by the headmaster of the Kayakosi Milan High School on 27/5/2020. PAN card of Bolenborough, where his date of birth has been shown as 31/12/66. It has to be actually 28/7 has to be, my lord. Identity card of Bolenborough, where his date of birth has been shown as 31/12/66. But identity card also 66, that is mentioned 27 has to be. Issued by the Assistant Executive Engineer, Height Subdivision on Executive Engineer so and so. all records appear to be clearly manipulated by the concerned dealing assistant Mohananda Sharma in condiment of Bolenboro, MR Lebar. The statement furnished by Bolenboro erstwhile MR Lebar has been fully examined along with all the relevant records in this regard. As stated in preceding paragraphs, Bolenboro appears to be equally guilty, although he has implicated Mohananda Sharma in the entire episode, leading to huge financial irregularities. It may be specifically mentioned that Bolenboro was due to retire on 31/12/16, as per the records verified. I have carefully examined and considered the facts, relevant records, and circumstances of the matter. In my considered opinion, Sri Mohananda Sharma is prima facie held totally responsible for allowing Bolenboro to continue up to July 2020 and hereby incurring unavoidable financial loss to the government exchequer of rupees 12,46,113 rupees. The authorities may desire to initiate appropriate disciplinary action against Mohananda Sharma and Bolenboro as deemed fit, as well as to recovery of 12,46,000 and so. The statement of Bolenboro elements and so. Now, my lord, in my reply, I filed affidavit in reply. It was filed on 6/1/25. I have stated in paragraph, my lord, 5, page 47.
Here.
Page 47, paragraph 5 in my reply, I want to point out, my lord, here that rightly placed this school certificate, so not only certificate but also in.
No, let us come to the inquiry report again.
Yes, my lord.
Inquiry report. What is that manipulation noticed on what basis?
Because possibly at the time of submission of the relevant records, my lord,
My lord,
regulation
this
of
matter,
service.
let bring the record, my lord. Even my affidavit also doesn't contain much. So
There is an inquiry report.
Yes, that is. Yeah.
So-
I am praying for my lord, pension, my lord, from the year 56, my lord.
First, let us understand what is there in the inquiry report.
From 2016, my lord,
Then
onwards, my lord. Because this recovery, my lord,
which date of birth is recorded in the service?
earlier it was 56, my lord. As it is evident from the inquiry report, it is, my lord, page 41. It was, my lord,
Then where did you get that birth certificate?
yes, my lord. Earlier certificate was, my lord, submitted at the date of birth as it is seen, my lord, here in the affidavit in opposition, they have annexed here 56, my lord. In their affidavit in opposition, page 39.
Who submitted that?
Well, one official person, with the help of official person, only petitioner put his thumb impression there, my lord. That certificate, it is shown as 31/12/56, page 39.
But once you put your thumb impression, it is a good.
Yes, it is admissible.
that is service.
In my lord, in my lord, AG, one, my lord, I have annexed in repetition, my lord,
Have
also.
you filed any application seeking cancellation of this certificate? Seeking a direction for cancellation if it is not correct.
No, my lord, that was not because it was allowed. Subsequently, my lord, it was stopped. May place page 47, my lord. In affidavit in opposition, I have written everything, my lord,
What
here.
is it?
Page 47. Affidavit in reply.
Yeah.
Last paragraph, my lord, last bottom paragraph. Therefore, the correction of the earlier wrong date of birth 28/12/56, as has been mentioned by the answering respondent, is no longer sustained in law. On the other hand, your petitioner, even after allowing to render his service till July 2020, he was stopped to work from the month of August to 2020. Therefore, it is not at all correct that all these records appear to be clearly manipulated by the concerned dealing assistant, namely Mohananda Sharma, in connivance of your deponent as well as. Neither your deponent is equally guilty with the said dealing assistant, nor he submitted his school certificate wherein his date of birth was 31/12/56, which is concerned about the causing of any financial loss of rupees 12 plus something of the public sphere. In altogether, there cannot be initiation of any disciplinary action also against your petitioner as pleaded by the respondent. Even after assuming but not admitting his date of birth is 56, 31/12/56 is correct, and his date of superannuation is 31/12/16, then also your deponent is entitled his retirement and pensionary benefit with effect from 1/1/17. So far, the recovery of excess payment of salary from 1/1/17 to July 2020, rupees 12 lakh something, as calculated by respondent, is not at all permissible in law, as there was no fraud and misrepresentation from the side of your deponent, which can be recovered from the retirement and pensionary benefit of your petitioner, who was a grade 4 employee of the PWD department. On the other hand, it is up to the service records on the basis of correct date of birth 31/12/66. It was admitted also at the time is the actual date of superannuation 31/12/26, which is yet to be reached. Resultantly, your deponent is entitled to receive his arrear as well as current salary till reaching his date of retirement. But now my prayer is that, my lord, if it is 56 is correct, my lord, then from the year, my lord, 17 January, my lord, he is entitled for the said, my lord, retirement benefit and pensioner benefit. So far, my lord, this excess royal is concerned, my lord, it was allowed in the year, my lord, from the at the time of regulation of his service. It was accepted also. He was not given any letter also. Just he continued. Suddenly he was stopped from the month of July, my lord, August 2020. So, my lord, it is there is a judgment also, my lord. So my prayer is that, my lord, let his, my lord, because otherwise his I card, voter ID, PAN card, all are 66.
Those are not the issue.
Then, my lord, he may be allowed to. My lord, I'm not praying for, my lord, up to 26. Let his, my lord, pension may be calculated from the month of, my lord, February, my lord, 2016.
It cannot be, my lord, because if there is a corruption, my lord, on his part, my lord, if you go by this inquiry report, my lord, then Rafiq Masi's ratio will not cover him, my lord. That is the thing.
No, Big party is for recovery.
Yes.
He's asking for pension.
Pension, my lord,
pension,
retirement
Do you
pension.
have to any disciplinary procedure?
So for this part is concerned, let him go in the lower court below, my lord. If it is 66, up to 66, voter ID, PAN card, Aadhaar card, he will establish. Otherwise, from the month of 17 years,
Who will establish?
petitioner will establish his case.
That is for you.
Yes,
that
but
is
that
for
is
him.
not different.
Because page 39 is apparent, my lord, his thumb impression, that left thumb impression, my lord,
No,
it's
no.
there.
See.
That is
You are alleging fraud.
exactly.
Have you filed any FIR, any complaint against him?
My lord, that I will, my lord, just inquire, my lord. Actually, my lord, I was not supposed to appear. My friend was supposed to appear. He prepared this case today. Because of traffic jam and everything, my lord, waterlogging, he could not come, my lord. There's a problem, my lord. But I know about this facts of the case little bit, my lord. But, my lord, if you go by this document even, my lord, that is what I, at the very inception, my lord, I said, my lord, that I,
No, if it is fraud, then you should have taken steps to pursue the matter, filing necessary complaints, etc. against him.
Only paragraph 30 minutes.
For what?
Only just short 2-3 lines. Same incident was there.
The excess amount has already been recovered.
No.
Is it recovered or not recovered?
Not recovered, because they have not calculated anything, my lord, not apprised me anything, my lord. Just stop to work there from the month of August 2020.
my lord, he is due to retire, my lord. That is his superannuation day, my lord. If you calculate from
No,
56.
you have already been retired.
Yes, retired, but nothing has been given to me. Yes, my lord. 16, yes.
But you said the recovery was not made.
Not made.
Not made.
Nothing has been given to me, even pension, anything. From the month of August 2020, nothing has been given.
Your affidavit doesn't say anything that any departmental proceeding, etc.
Yes. They have annexed there from the inquiry report.
My lord will go by his prayer, my lord. What he is seeking? He is seeking reinstatement into the service.
That was there.
That was there.
After
Not, it is on record, my lord, in page number 13.
All right. If he's seeking reinstatement, now he's retired, so he can't be reinstated. His case is that even if it is considered to be 56,
56,
then also he's entitled to
yes,
pension.
the month of.
Now, if you say that 56 is or 66, I don't know if it's
Hmm.
fraud.
Inquiry report itself evidence.
You see, if if 56 was fraud, then why will he give another date of birth certificate? Assuming that it is forgery or anything, it is relatable to 66, can't be 56.
If it is 56, he is out of service.
He's out of service.
Out of service. But
the
he is
date
seeking
of his superannuation.
66, thereby he is telling that his retirement date is on 26.
Right. He's now accepted that even if it is 56, you have retired me, I'll go. But I'm entitled to some pension.
My lord, now
Yes.
wisdom has come into him, my lord. He, after he has,
It's the charm of practice, huh?
my lord.
Thinking on leg.
No, no, not my friend, my lord. I'm talking about the petitioner, my lord. Petitioner, my lord, after,
Your friend is thinking on his behalf.
yes, my lord. That is his my duty about to think, my lord.
Now, unless you say that there is a department proceeding pending or some punishment has been awarded, you know the provisions of 20.
Yes, my lord. My lord will fix a part hard matter, my lord. Next week, I will take a small instruction. My lord can dispose of, my lord.
Yes.
My lord, according to me, my lord, if it, my learned friend, according to me, my lord, up to my lord, pension may be released and recovery may not be, my lord. From the month of my lord,
No, but
60
you
itself.
are coming to the court with two birth certificates.
Hmm.
You have to answer that.
Sorry, my lord.
He has come before.
You have come before the court with two birth certificates, two different days.
Two different things here.
And
Subsequently, I have received the voter ID card also. Then
my lord,
surprise.
and the most vital question is,
Whatever you have received, we are not.
the most vital
You-
question is
we are
that, my
not
lord,
going
he has never approached the department for correction of date of birth, my lord. Even a span
No,
of
no, regularized him from the
10 years, my lord, 10 years.
no, regularized on the basis of 2066.
No,
Yes.
these department proceedings are there.
My
And if not, then we'll consider 56 that whatever amount is there.
Yes.
My lord.
Possibly initial stage 56 it was, my lord. At the time of regulation, he has supplied they are 66. It was accepted also.
What is it?
A voter card. That is also 66. PAN card, voter ID.
Not a
Yes, yes.
document for it.
Age plus.
Yes. 66.
Supreme Court,
But otherwise,
yesterday when I read, my lord, even Aadhaar card is not acceptable for date of birth. Honorable Supreme Court has stated. My lord will fix this another it, my lord.
Come back on. Third,
it will be as a part of it.
3rd of June. The third court completed. Let's do whether any departmental proceedings are pending, like the petition, and if so, the particulars like, and also whether the excess amount stated to have been overdrawn by the petitioner has already been recovered. It is the practice of case court for next day. Read that. Please take on.
As a part of it.
Right, partner.
Part of it. Right.
Yes, Mr. Yeah.
Well, the petitioner is a civilian motor driver working in army. He has been recovery from salary has been done on many occasions without having any notice proposed or departmental proceeding. I'm coming to page 41. Relevant page is 42. he was transferred from Calcutta to here at Misamari. And when he was transferred, my lord, that one service particular has been attached along with his transfer order. And from the service particular at serial number 9 or page 42, mentioned that one amount has been 14 days pay fine. Serial number 9, recovery amount. Individual has awarded 14 days pay fine under Army Act 39A on 3 September 2022. Pay fine should be recovered from the individual by receiving unit. Without any shockers or notice or order, it has been mentioned that recovery will be done. Then when he joined here, he submitted a representation at state court.
Yes.
Page 43 has submitted the representation. Here representation here stated that I, Sri Suresh Kumar, civilian motor driver, posted in, I have been posted out from 5682 ASN battalion. Sir, I want to place some point before you to prove that commanding officer sir has done injustice to me. Sir, I went to leave after processing my leave application by Havildar so-and-so, so-and-so, so-and-so. Then para 2, sir, my application dated 4th August, 11th August, 17 August are enclosed herein. Sir, it was my compulsion to go to home on leave as because my mother and wife were sick and due to emergency I went to leave. Sir, one child of my family who is sick and hospital admission slip attached here. Sir, after availing CL of 8 days, I have been informed on 39/2022 by office that my leave has been treated as AWF. I have been ordered 2-3 days army drill whereas I am a civilian employee. Sir, on 3/9/22, I have been sentenced for 14 days pay fine as final. I have been illegally given penalty. I want inquiry on this. Provide me justice following rules. Then para 9. Sir, my family was admitted in hospital. I was on leave and the order dated 7/9/2022 was sent to my quarter by NK Mandal and I told that I have been posted out. I was not informed earlier what was the urgency for issuance of movement order. Sir, kindly consider this application and provide me justice. So then thereafter, my lord, as page 47, he has submitted another representation regarding justice. With regard to I number so-and-so motor driver working under you, that's where I want to submit some points so that I can prove that Lieutenant Colonel Rakesh Kumar Yadav QIC sir has committed many wrong with me. They sir kindly inform me in writing as to why I have not been given granted RH leave, regular holiday leave. Yes, sir, Government of India has appointed.
Order is by whom?
My lord,
By the army authority.
my lord, yeah. They are referring that army under army act and army act I have enclosed here. These are civilian driver. Terms condition
Where
appointed.
is that? Where is that army act?
My lord, that I have enclosed here army act.
Whole act.
135 page.
135.
Para 39, rule 39. Absence without leave. Any person subject to this
You
act.
show us that
My lord,
you are not, you are excluded. You want to say that army act is not applicable.
not applicable, but they in their condition.
On what basis are you saying that?
My lord, I am saying showing that my appointment.
See the appointment order.
My lord, let please.
By the army authority.
Yes, Lord. And specifically mentioned that he
I will
have
show.
clause H and I that
I will show it.
Hmm.
Page 40.
Page?
40.
Yeah.
This is appointment letter.
Yes.
Under the para 2, under the authority of Army Headquarters of Ministry of Defence Army, Branch New Delhi, number so-and-so, 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 stated, you have been appointed as CMD, Civil Motor Yard Driver. In pay band so-and-so, grade pay so-and-so, plus usual allowance as admissible in central government servant from time to time. Against the OBC vacancy, there is civilian DT unit. The service terms and conditions will be governed under the following rules. The post is temporary but likely to become permanent in accordance with rules in force. You will be on probation for a period of 2 years from the date of your appointment. During the period, if your services are not found satisfactory, you may be discharged. Then para C, in accordance with Central Civil Services Conduct Rules 1965. He will not be eligible for appointment under Government of India if you have more than one spouse living. A declaration this effect will be furnished before
You come to serial number H.
Yes, that I am saying. You will be subject to the Army Act 1950 Army Order for discipline purpose. That is what I am enclosed this Army Act. That Army Act shows, this is the say that you may impose a penalty after the inquiry. I am showing that 135.
Your first argument was that Army Act is not even applicable.
Well,
Your primary argument is that Army Act.
No, I have enclosed everything. That is the discipline, but I am not submitting that they cannot, but procedure is there. What to do?
That is a prayer, Lord.
The
Your
discipline.
prayer is there.
Well-
You opened your arguments to say that they proceeded and it is not applicable because you are a civilian tribe.
Because there is not express that is that Army Act, I will be proceeded under Army Act. That is for discipline
What do you
purpose.
mean? Serial number H is very clear that you will be subject
Yes,
to
yes.
Army Act.
That is what I am showing. Even if I am under that, then they have to follow this procedure. I am 135. For discipline purpose, but not so that I am showing 135, please. They have recovered without any departmental inquiry. I have not been informed. That is what I submitted series of representation. Quite regularly, my recovery has been done from my salary. Then they have showed that you have been imposed 4 penalty. That I will show.
Come to page number 2. Page number 7, para 2.
Petitioner is motivated for discipline purpose.
Last
Further,
paragraph, last
is-
line. Last
yes.
line.
Further, it para 2 it has been stated petitioner will be governed by the central government service for all purposes are issued by the Government of India from time to time.
Right.
He will be subject to the appointment letter is showing. What I am not showing that appointment letter say that for discipline purpose, Army Act will applicable. For discipline purpose, Army Act for discipline purpose, Army Act shows that you will be issued charge sheet and proceeding will be done.
All right. So after the appointment, what happened?
After the appointment, he was transferred, he served there at Kalka unit, then he has been transferred here at Nisamat. And along with this transfer order, this service particular, he has come to learn that individual has been awarded 14 days pay fine. That 14 days pay fine, let them show what proceeding they have done.
You take us through your anecdote.
Yes, page 42.
Yes.
Recovery amount, serial number 9. Individual has awarded 14 days pay fine under Army Act Section 39A on 3 September 2020. Pay fine should be recovered from the individual by receiving unit. Section 39 I have enclosed at page 135.
Yes.
To impose that penalty, condition precedent that there must be an inquiry. Yes. That is first instance. Then, my lord, again and again there have been, and page, my lord, I am coming to one, my representation I am showing, lordship. Repeatedly, his salary recovery has been made from salary without having proceeding. So he has submitted one representation at page 110. Against that representation, they have issued an order that you have been imposed with 5 number
Section 39
39, page 134.
says
Absent without leave.
absence without leave.
Any person subject to this act,
Then where is the question of recovery?
that is what I am saying. Who commits any of the following offence, that is to say, absent himself without leave or without sufficient cause overseas leave granted to him, or being on leave absence and having receiving information from proper authority that any corps or portion of corps or any department to which he belongs has been ordered to an active service fail without sufficient cause. Without sufficient cause. He has submitted representation that I have some cause. Without sufficient cause fails to appear at the time fixed at period or place appointed to exercise duty or.
So
Where-
these are instances of absence without leave.
Yes.
Where is the procedure?
Procedure I am showing. Shall be, then last line, my lord, after G. G without leave from his superior officer or without due cause absent himself from school any duty order attended. Shall on conviction by court martial. Where is that court martial proceeding? Where is my conviction?
Where is the provision for conviction by court martial?
That is the provision of that is court martial. They have not done any court martial.
What is the provision?
Court
Where is
martial.
it provided?
There is court martial proceeding. They will issue notice that you will be asked to court martial.
Section. Section.
Court martial provision, my lord, section have
You
not
don't have the
included
Army
that.
Act.
Have not included
You don't have the Army Act.
it. Court martial proceeding, the proceeding to be done.
That much we understand. We are asking you where is the provision?
That is what I am not clear. It was not included.
Got it. So Army Act.
Proceedings of general then district court matter. Sitting of members. The members of the court martial shall take section 75. The members of the court martial shall take their seats according to their army rank, responsibility of the presiding officer. The presiding officer is responsible for the trial being conducted in proper order and in accordance with the act, rules made thereunder, and in a manner befitting the court of justice. It is the duty of the presiding officer to see that justice is administered and accused that a fair trial, and that he does not suffer any disadvantage in consequence of his position as persons under trial, or his ignorance or of incapacity. Power of court over address to prosecutor and accused. The prosecutor may not refer to any matter not relevant to the charge or charges has been before the court, and it is the duty of the court to stop him from the so doing and also restrain any due violence, languages, or want of fairness or moderation on the part of the prosecutor. Court shall allow great latitude to the accused in making his defense. He must abstain from any remarks contemptuous or disrespectful towards the court and from coarse and insulting languages towards others. But he may, for the purpose of his defense, impeach the evidence and the motives of the witnesses and the prosecutor and the charged other persons with blame and even criminality subject to it all and the liability which he may be. Court may caution his accused and the revelation unless stop his defense solely on the ground of such irrelevance. So court martial, there must be a notification that court martial procedure will be done, and then this procedure to be followed. No court martial proceeding has been done. Let them show from record that court martial proceeding has been done.
Some charge sheet was,
Trustee, we have annexed lordship.
under-
All opportunities we have given.
where is the procedure prescribed? There must be a procedure laid down. That in such cases, what will you do?
Procedure on trial of the accused person together, section 17. Rule 17.
Lordship, we have only imposed pay fine to him. His absence period, we have regularized as EOL.
That's okay. We are trying to understand
No.
that charge sheet that you have filed against him. It must be prescribed under some act of the root. Where is it? Under what provision? Your affidavit is not clear. Your affidavit says that there were as many as four charges.
Not true. 4 occasions.
Four charges or 4 occasions or what, but 4 charges
Not
on the same charge sheet, and he was charge sheeted on 9th of December 2020. What is the procedure prescribed?
Section 39 is my lord, court martial proceeding. To pay fine, court martial proceeding.
Hmm?
82
Section
of the
39 says,
RTA.
section 39 says,
Hmm.
without leave from superior officer without due cause absent, then shall on conviction by court martial. They can done only after conviction. Section 39, page 135 is clear. I was not convicted, I was not court martial procedure not followed. Only they are showing that some documents has been have been enclosed in that.
Lordship of section 80, 88, 81 and 82.
তারপর I could yes, carry on. Read it.
Punishment of person other than officer, junior commission officer, and warrant officer. Subject to the provision of section 81, a commanding officer or such other officer as is with the consent of the central government specified by may in the prescribed manner proceed against a person subject to this act otherwise then as an officer, junior commission officer, or warrant officer who is charged with an offence under this act and award such person to the extent prescribed one or more of the following punishment, that is to say, imprisonment in military custody up to 28 days, detention up to 28 days, confinement of the line up to 28 days, extra guard or duties, deprivation of a position of the nature of an appointment or a corps or working pay, and in the case of non-commissioned officer, also deprivation of acting rank or reduction to a lower grade of pay, or forfeiture of good service and good conduct pay, severe reprimand or reprimand, fine up to 14 days pay in any 1 month, penal deduction under clause G of section 91, limit of punishment under section 80. In the case of an award of 2 or more of the punishments specified in clauses A, B, C, and D of the said section, the punishment specified in clause C and clause D shall take effect only at the end of punishment specified in clause A or clause B. When 2 or more of the punishments specified in the said clauses A, B, and C are awarded to a person conjointly, or when already undergoing 1 or more of the said punishment, the whole extent of the punishment shall not exceed in the aggregate 42 days. The punishment specified in clause A, B, and C of section 80 shall not be awarded to any person who is the rank of non-commissioned officer or was at the time of committing the offence for which he is punished of such rank. The punishment specified in clause G of the said section shall not be awarded to any person below the rank of a non-commissioned officer. Punishment in addition to those specified in section 80, the chief of the army staff may, with the consent of the central government, specify such other punishment as may be awarded under section 80, in addition to or without any of the punishments specified in the said section, and the extent to which such other punishment may be awarded.
Sorry, you were reading section
80, 81, 82. These are summary trials. And
the for punishment of persons other than officers,
Junior-
ratios, and warrant officers. 29 clearly says conviction. How to correlate the section?
So in our affidavit also, we have stated that the section, punishment, paragraph 13, I have stated, punishment was given as per section 80 of the Army Act. Commanding officer has the power to, as per the vested power, he had acted in that. It's not only absent without leave. One occasion is absent without leave, others are other lordship. Without sufficient cause failing to appear at the time fixed at the place appointed for duty. Another is using insubordinate language. And the next is disobedience and quitting the line of march. And some is that he had violated some rules that is for social media use. So those are all. And after complying,
These are allegations, whether proved. There is the findings, conclusion with evidence.
we have given opportunities, lordship, we have annexed those, but in our document, lordship will see that the individual has been handed over copy of tentative charge sheet. He has refused to endorse signature as it is an acknowledgement and purview the following, and that is done by witnesses, lordship. He refused to accept those things, and he is one of the thereafter also, after filing of this case also, lordship, 2-3 such incidents was happened, but as there was a stay order, we have not yet recovered any amount for those offenses also, lordship. And this is not a case of recovery. This is only fine. I have also annexed stated in my affidavit that charges and against what fine we have imposed. At page 153 to 155, lordship will find it. Proceeding, lordship will found from page 212.
What is the punishment?
Lordship, page 150, 152, sorry, 153.
Deduction.
Yes, rigorous imprisonment and 14 days pay fine in one. This is the table I have given. So penal deduction and In one cases, there are some rigorous imprisonment and other
Page number
page number 153. The
153.
yes. So leaves were adjusted against UL.
There must be residuary powers of the commanding officer to pass such order to the act.
That 80, section 80, Lordship, commanding officer. He is not an officer. The commanding officer has the authority. So Rule 22, Lordship. Hearing of charge, how to power of commanding officer, Lordship, Rule 22. And page 1 157 to 158.
Have you mentioned here that this is the issue to waive
Yes, Lordship, page 157. The procedure I have stated.
procedure you have stated, but the facts of the case, what step did you follow the procedure?
Yes, Lordship, may kindly come to paragraph 15, Lordship. Page 157. May I read, Lordship? So from the third last line. So the affirmation of the petitioner that he cannot be tried under Army Act 1950 is absolutely incorrect. Whenever a charge is levied against an individual subject to Army Act, then as per Army Rule 22, hearing of charge takes place. The procedure is as given below. Summary trial is a form of disciplinary action. Hence, hearing of charge under Army Rule 22 read with Army Order number 6 of 2009 must be held before the accused in match up for summary trial under Section 80 of the Army Act 1950. The first step towards summary trial under the power of COIC cadre is preparation of the offence report as per IAFD 901. Separate charge sheet is not required to be prepared of summary trial to be held under Section 80 of the Army Act. Proceeding of summary trial are recorded on the offence report itself in the handwriting of the CO or officer disposing the case. The evidence is heard orally and same is not required to be reduced in writing. The accused, NCO or OR cannot claim to be represented by a counsel by defending officer or friend of the accused at a summary trial. While doing a summary trial under Section 80 of the Army Act, read with Section 81 and 82 of the Army Act.
This is the procedure you have laid down. But
Yes.
in the case, the facts of the case, where this adhered to, was this procedure followed?
Yes, Lordship.
Where have you
Lordship, that I have shown the tentative charge sheet.
come here? If you see paragraph 15, you have laid down the procedure.
Yes, Lordship.
Where have you stated on which date, how the procedure commenced and all these details, where are they?
I have annexed, Lordship. Yes, Lordship. This paragraph is a long one and everything is stated. Page 160, offense report was given to the petitioner on 6 December 22 for violating written order and abusing superior officer. Fearing that he will be given punishment to his misdeed, he tried to run away from the cantonment on 7 December 22, but was caught before he could escape out of the cantonment. During the proceeding, Rule 22 of the Army Rules and Section 80 of the Army Act were strictly followed. The allegation of the petitioner, like beating up, stealing of phone and personal document, etc., were investigated and all were found to be baseless and false. And that I have annexed the tentative charge at page 212. That annexer I. And he refused lordship. Signature of the witnesses are very much there. And all the proceedings are given here. Proceedings are his page 214. He was asked to cross-examine, but he declined that. Then lordship, I have stated that the charges were read over and explained to him. However, accused refused to endorse his signature on the document. Opportunity, all the procedures were followed, lordship. But he have not participated in the
Where is
proceeding.
Power is reserved to the commanding.
But section 39 have read court martial proceeding to be followed.
There are other charges against.
These charges,
That is for officers. 39 mostly for the officer. He is not an officer, junior.
no. Any section 39 is very clear.
Section 80, 81 and 82.
No, the procedure followed in your case prescribed under the act. How do you say that this is the only procedure to be followed?
These are for the formation of the tentative charge sheet. This procedure acts as this procedure for tentative charge sheet. Thereafter, my lord, the proceedings will be done by court martial. That is
Where is it?
that is there. Tentative charge sheet, and then my lord proceeding is there.
Where?
Section Rule 37, my lord, say convening of the general and district court martial.
You're not correlating. The powers of the commanding officers are there. Proceed. You are saying that it must not be by court.
This is my lord, the procedure that I have enclosed
This is summary court martial, Lordship. And commanding officer has the power.
to pay fine without leave from superior officer without due cause, absent himself, shall on conviction by court. Section 39, 130. Without leave from superior or without due cause, absent himself from any school when duly ordered to attend there. Any person subject to this act. Section 39 says, commits any of the following. They have, although I applied for that leave, I have in my representation, I have details stated, and they are saying that that is without leave. They are saying without leave, that is why it's section 39G, without leave from superior officer shall on conviction court martial. Pay fine is due to this that I was absent from this. On all four of it. Not due to disobedience, that pay fine. 14 days pay fine, 28 days rigorous, 14 days pay fine, 7 days pay fine, 9 days rigorous, 9 days pay fine. Rigorous immigration and pay fine, both. For pay fine, my lord, that is, I must be, that is, conviction should be there.
Where is that?
Section 39. Pay fine. Section 80.
Section. Where is summary court martial?
Summary court martial page section 3. Where 106, Lordship, section 106. Sorry. Rule, Lordship, rule 106.
Procedural. You are saying that the proceeding held by the superior officer on summary.
That is rule 22, that commanding officer has the power, Lordship. 106.
106 is the proceeding.
Proce-
106 is the proceeding.
It was done as per rule 22, Lordship.
We'll
As
continue next week.
Lordship.
Carry on next.
অলপ পঢ়ি আছো মই বাচ্চা দিন হওক
Next Tuesday.
Apply.
হার্ড
We'll have to carry next week. Carry on next some other day. We have to write now. Right. What is the matter about? What is this matter about?
This is, my lord, this is the second round of litigation. The other co-accused have been reinstated in service with minor penalty, and the petitioner has been removed from service,
Termination.
removed from service following a departmental proceeding. Your Lord. All others have been reinstated.
The records are available here.
And on the last occasion, probably your lordship wanted to have the records, my lord. Only-
Records, sir. Records received.
Ready?
Out of the 7 or 8 persons, only one person was given the compulsory retirement penalty, and others are minor penalty.
You are essentially praying for parity.
Parity. I am relying the Honorable Supreme Court judgment, Ajendra, and on the same issue, similar case, this Honorable Court passed a order in favor of another employee, where compulsory retirement is given. my lord.
All right. We'll carry next week, Tuesday. Heard?
Lord, any other day other than Tuesday, my lord. Thursday, my lord.
Thursday or 10th. We can have it on 10th.
My lord.
10th. Okay, fine.
Diploma.
May,
Diploma.
June.
10th of June. 10th of June.
10th. Respondents will keep the